I apologize. This is Dan Morris. I'm not getting sound.
Testing 1, 2. Is it going through now?
Yes, it is. Thank you so much.
I think I needed to turn on the turn. Now it's a problem. Here.
3, 4.
Dan Morris, can you hear us?
Yes, I can now. Thank you.
Dan Giovanni, can you do a test?
Testing 1, 2, 3, 4.
Can you hear that?
Yes, I can. Thank you.
Okay.
Mr. Morris, do I need to go back and restart?
No, thank you. Not for the preliminary matters. Thank you.
Thank you. So I've just completed the introduction of NDs for the commissioner. I'd like to make an announcement. The public testimony. According with chapter or WC will allow for public testimony before proceedings and before deliberation on major agenda items. That's 2 times, once before and once before deliberation. Our first order of business is the adoption of the August 24th, 2022 minutes. Ms. Swan, has there been any written testimony submitted on this matter?
No, Chair.
Ms. Swan, are there any members of the public signed up to testify on adoption?
Not at this time.
Thank you. Commissioners, are there any corrections or comments on the minutes? If not, is there a motion to adopt the minutes of August 24th?
Mr. Chair, Hibashi. Move to adopt the minutes.
October 20th.
August 24th, 2022. And assumption. Mr. Chair, Mike Yamada, second.
Thank you. Motion has been made by Commissioner Hibashi and seconded by Commissioner Yamane. In favor of adoption of the minutes, please say aye.
Aye.
Aye. Any opposed? Minutes are adopted. Thank you. The next agenda item is the tentative meeting schedule, which we presented by Mr. Ordenbanger.
Thank you, Mr. Chair. On September 14th, 15th, 16th, staff and commissioners will be attending go on Hawai'i. On September 21st, we will be taking up this matter, if no requiring possibly adoption order. That will be a hybrid meeting. On October 5th, we'll be on Maui for the full meeting recording matter. On 6th, we will be on, again, be on Maui for the Waikiki. For the bill of money petition. October 19th to Maui for the possible adoption orders. On November 2nd, we will be in Kona for new event Bancorp. On November 16th, kind of rescheduled one of my matter on Maui. And that takes us through the December, currently our December schedule is open for participate. Hearing session.
Commissioners, do you have any questions regarding the schedule? Mr. Harmon. Thank you. Our fourth order of business is action on SP 22-414, Yamada and Sons Incorporated. This agenda item is to consider a special permit application to allow the establishment of a quarry operation, related improvements, and activities on 37.882 acre portion of a larger 2,407 acre parcel of land located in the state land use agricultural district within the district of Waiakea, Southeast, by PMK 3-1-013, semicolon 002, portion thereof. Let me briefly explain the procedure for this document. First, I will recognize the written public testimony in this matter, identifying the person, organization, with the next, I will call for members of the public to testify on SP 22-414 Yamada and Sons. All such individuals will be called in turn by the chair. If testifiers wish to testify virtually, will enable the audio and video from the virtual. Oh, that is not, this is in person. Members of the public will have 2 minutes to provide their testimony, stand by after the testimony to respond to any questions parties or the commissioners may have. When all questions have been completed, the chair will excuse the witness, put them back into the viewing audience, and call the next witness. After completion of the public testimony portion of the proceeding, the chair would like the petitioner to make his presentation. After the completion of the applicant's presentation, we will receive any public comment from the County Planning Department, State Office of Planning and Sustainable Development. The commissioners will ask questions of the parties at the conclusion of each of the presentations. At the conclusion of the party's testimony and the commissioner's questions, the public will be granted the opportunity to provide testimony in a similar manner that was set forth previously. After the second round of public testimony, the commission will conduct its deliberation. The chair would also like to note that from time to time we'll be calling short breaks, typically about 5 to 10 minutes once per hour. And we'll probably take a lunch break. So are there any questions on our procedure for today? The parties need to identify themselves for the petition.
Good morning, Mr. Chairman, members of the commission and executive officer orientation. My name is Darren Arai. I'm a land use planning consultant residing in Seattle, and I'm here assisting the applicant Yamada and Sons, who's represented here by Shelby Lynn Yamada, who's sitting to my right.
Thank you. From the county.
Good morning, Commission. I'm Maria Kai, Deputy Corporation Counsel representing the Hawai'i County. Good morning, Deputy Corporation Counsel and Judula, representing the Planning Department. Also present is Jen Zero and Scott.
Good morning, Deputy Attorney General Brian Yee on behalf of the Office of Planning and Sustainable Development.
Very well. Thank you. Let me update the record. August 1st, 2022, the Land Use Commission received a preliminary copy of the decision and a portion of the record of the Planning Commission's proceedings on the applicant's request. August 15, 2022, the Land Use Commission received the minutes and transcripts to complete the filing. An acknowledgement email was sent. August 29, 2022, in the notice for this September 7, 2022 meeting, to parties statewide and to the Hawaii mailing email list. Time for public testimony. I will now recognize the written public testimony submitted in this matter, identifying the person or Ms. Kwan, has there been any written testimony submitted on this matter?
No, Mr. Chair.
Two of you? Ms. Kwan, are there any members of the public here today that wish signed up and you wish to testify on ST 22-414 Yamada and Son?
I don't see anyone in the audience, Mr. Chair.
Look in the room to be sure. Okay. So now proceed with the presentation. Petitioner, will you please provide your presentation?
Good morning, Commissioners, once again. As we sit here before you today, this has been approximately a 3-year journey by the petitioner to go through the process and securing the necessary land licenses and land use permits that we now have before you today. It started with the preparation of necessary studies to inform and support the final environmental assessment that was adopted by the state. Proceedings before the land board with the filing of a special permit application with the County of Hawaii and its recommendation to you, with a favorable recommendation to you. The project site itself is, for all practical purposes, is an extension of the existing 14.99 acre quarry site that's currently in operation by the petitioner, Yamada and throughout this 3-year journey, there has been a lot of various assessments of the project. And adjustments were made in order to conform with some of the considerations and constraints that apply to this particular site. Most importantly, the original proposal was for just over 50 acres of land, but due to the existence of an existing OTR forest within Uluhe understory, the applicant decided to exclude that portion of the project site, reducing it to its current roughly 38 acre land area. What was very profound was throughout the whole process, various concerns were identified primarily with the nearby Kyokaha Farmers Association, as well as coming from the Department of Hawaiian Homeland. In proceedings before the Windward Planning Commission, the applicant did take time to defer the proceedings in order to go ahead and consult with the association and the HHL, which culminated in a series of agreements and conditions that were presented to the commission and subsequently adopted. Throughout this process, we appreciated the review of the planning director and his recommendation for approval. We also appreciate the actions of the Windward Planning Commission to also recommend approval of this permit. And hopefully with the information that is presented on the record, we can find likewise to support the issuance of this special permit application. So with that, we we stand ready to answer any questions you have. Oh, and I should mention, we were aware of recent communication from the Office of Planning and Sustainable Development, dated September 6th, offering a proposed condition that would address potential concerns regarding hazardous wildlife attractions to the property and the applicant to mitigate those concerns, and the applicant is supportive of the proposed condition. Again, that concludes my big presentation. And we stand ready to answer any questions you have.
Thank you. Commissioners, any questions for the petitioner? You can ask it directly.
Just for clarification, mitigation for a particular concern that you have, and just what is that?
Yes, the letter was very broad. Yeah, so I was just wondering what kind of mitigation measure would come to this?
Specific to the concerns expressed from the Tokyo airports, that mitigation would be simply not to create anything else. That would be like a wetland type of situation where standing water would be allowed to occur, and then birds, I'm not sure what the proper term, wetland birds, I guess, would be attracted to that particular property. We know that that those same actions and efforts are currently occurring within the current 14.99 acre site located immediately adjacent to the west of this project site. And should this special permit be approved, the applicant would simply translate its current practices onto the new 38 acre quarry site. I hope I answered your question.
And I hope it works.
Thank you very much. I appreciate the brief presentation of you've been reading material. And I appreciated also the outreach to the Hawai'i Farmers Association and Department of Land Homelands. That's really important to have those joining landowners participating in the process. I just have a few questions related to this is specifically condition 15 related to the appeal. And I too appreciate the fact that you reduced the size in light of the OBL forest. So, however, will be tested with for the some opioid trees that are still in healthy condition.
My recollection from reading the environmental assessment and botanical survey is we identified some idea from the property, keeping in mind that a large percentage of the property has been heavily disturbed. So you do have basically most of the properties are occupied by invasive type of species like LBC, for example. Should there be I did not really see any indication that the ohia that was encountered during the survey was infected in any way. But it's a standing requirement and obligation of the applicant that should those trees, infected trees, been encountered and proper mitigation happen. And that is
and I saw that, and I was more, one of my concerns was if there are healthy ohia, because you think to be no ohia trees can be removed, they're going to burn and bury. But if they are happy opioid, it would be a shame not to repurpose them for, if there are small organizations, or individuals, or if there are, so, I mean, I would ask that they consider that before the opioid treaties, that there is an evaluation of the health of opioid treaties, that if there are some supplements that need to be removed, that part of the mitigation includes an attempt to try to find suitable places to take it, because given how significant opioid is going. So I would ask that we also consider.
Petition is an agreement with that.
Very good. The other question I had is, now this, has there been an assessment as to the impacts of the proposed activity on the adjoining healthy, the opioid forests? So I know you're looking at dust, but are there monitoring for any potential impacts of the proposed project? Because when I read the condition 15, it said to protect the opioid from fraud on the subject property. So it doesn't necessarily address monitoring on the adjoining opioid forests. So I'm wondering, how is an assessment of potential impact? If not, I would want to see that there be monitoring of not only the subject property, but the adjoining opioid forest to ensure that the activities does not adversely affect the healthy opioid forests.
Maybe one way of addressing that is there was a consultant who conducted the biological survey, and he is well informed and has it. So maybe the best way of addressing that is prior to commencing operation, maybe the consultant can be consulted to see how best to ameliorate any impact by the ongoing activities onto the existing OPL forest. The other thing what you're saying, part of the mitigating actions by the petitioner was, and if you go out to the particular site, if you're driving on Lima Road that provides access to your property, if you're not careful, you might tend to just simply drive past the existing quarry site. The petitioner, in order to mitigate any visual concerns and to help with dust control, has left intact the existing forest along the perimeter of the project site, and they intend to do the same. So hopefully that would also provide a physical barrier to help with the transmission, harmful transmission of
And I appreciate that. I just don't want there be, because it appears that there's a buffer. And again, I know that the petition could reduce the size of the proposed activity to preserve that with your forest. And I'm sure the community and everyone appreciates that. And I do. So, but it's just, as part of the assessment, if you also look at, I would recommend that there be, there's a lot of other conditions related to monitoring for a lot of other species. I forest that area, that there be monitoring outside of the subject property to ensure no adverse impact of the activity. And I know condition 18 deals with your after the effective date of the permit. You have to get your consultant to tell how much time you have the association. Part of the documents. The comment is regarding the program. So until And, there seems to have been some really good debate on the part of the application to work with the community there. Will there be ongoing engagement with DHL and the KPFA throughout the term of this project, just to ensure that if there are any concerns, or they have a vehicle or an opportunity to address them with
Yes, that's it. To have ongoing communication with all the teacher.
So I appreciate that DHL stepped up as well as the association to participate in this. You have adequately addressed all the concerns that I had. So thank you very much for the
Commissioner James. Commissioner, I was going over your presentation that you, position 41. And it says here that you're increasing the amount of acreage. Would that correspond to an increase in amount of mining activity? In other words, additional amount of tonnage you're extracting from?
At any given time or time frame, not necessary, but it is going to increase for the life of the license, it will increase the overall tonnage that we're going to actually.
In that report, you indicated that the presentation that you have, you indicated 25,000 tons of raw rock per month. Extract. Is that the amount that you're extracting now?
Yes,
Or
roughly.
is there an increase?
Yeah, so roughly that's the amount per month that we're kind of extracting out.
But we see the same.
Yeah, so it'll be the same, but the life of the license for this area is longer than the current one we've been in. So over the whole license term, it'll be more for sure.
Yeah. You also indicated about 4 to 5 rock holding trucks, 8 to 10 technically, about 3 trips per hour exposed for. Yeah. Is that the amount of trips now?
Yes,
And is that the amount foreseeable no more than that?
correct. So currently we're using the rock haulers. So it's 3 to 4 rock haulers per day, making up roughly around 3 trips per hour each. But there has been a condition that the Department of Environmental Management put in there where they wanted us to discontinue the use of the rock haulers. So if we have to do that, then that's when it'll switch over to 8 to 10 tractor trailers.
Yeah.
It's smaller inside.
And I was looking at the map that was provided in that presentation with location map. I was just wondering where your these are.
Okay, so where the rock haulers would be going to, it's stated as our base road, but it's actually the rock crushing site. So it's along Ho'ola'ima Road. There's an access point. So all of the traffic will go along Ho'ola'ima Road and the rock hauling traffic.
Is there any maps showing?
Oh, yeah, that should be. Oh,
I was talking about.
yeah.
And my only concern is that I'm not sure whether or not there'll be, I was asking this question to you about whether or not there'll be additional impacts on the road utilized for the purpose.
Yeah, there's no foreseeable.
Is there any kind of proposed development plan near the rock crushing facility that would impacted by these trucks on a daily basis. 3 times per hour on a daily basis to a number there.
Olau Lima Road provides access to various county activities, such as the landfill, which was recently closed, the transfer station, peak shooting range, county drag strip, mass transit station. All of these receive approval from, it's basically the use of state lands, right? So
It's more like an industrial area.
yeah, so it is a shared. Olau Lima Road itself is not identified as a county roadway. It's actually just a driveway. Because again, it's a driveway that goes into this much larger land area that has all these various uses being established. Olau Lima Road that goes from Leilani Street, which is the county road, through the transfer station by the landfill to the applicant's project site, was actually widened with the assistance of the applicant as well. So it was widened specifically to accommodate the larger rock haulers that the applicant used. And I know that I've driven past them on a few occasions.
Is it a regular road or dirt road?
It's paved. And there are sections where it actually splits into two travel ways, specifically to separate the traffic of the rock haulers from the more pedestrian-oriented vehicles.
Being on the state land, who owns that?
I think basically the county maintains it. One would argue the state owns it, but the obligation is upon the county to maintain it simply because it services so many county-related operations.
I'm not voting.
I have the county attorney right next to me, so she'll definitely might say something wrong.
Thank you. You can find it. Sorry. Thank you. I wanted to see.
Within your exhibit, I think there's a page 874 that shows a map that outlines the project site in red and the applicant's rock crushing site.
Is it good? I wasn't saying it was not, but I just wanted to be sure because you can't review anything that's not in the record. And I want to make sure that this is part of the record. Can you refer to this page so that it's clean and covered?
Thank you, Commissioner. This is Christian Cave, County Planning Department. That particular image is within your record multiple times. Initially on page 7 of your record as part of the applicant's application, and also the same image was used in a PowerPoint presentation. Not exactly sure what page number, 874. So it's in there multiple times.
Thank you. Thank you, Mr. Earl. Commissioner?
Okay, I got a question. There was some issues raised or concern on the dust in the noise. I believe from Homestead to Kakao. So is it the company looking at having a legal or some kind of mitigation to prevent the continued noise recurring? For people who are paying more than most and stuff. So, something kind of the problem.
What was very, very helpful was that concern was raised just prior to the initial proceedings before the Wetland Planning Commission. Once the hearing was deferred, it gave us the opportunity, especially Ms. Yamada, to host several meetings with the association, including an actual site inspection where certain members, committee members, association members, I should say, actually went to the site itself. Note that the proposed quarry site is actually, there's an existing quarry, the 14.99 acre quarry that they're currently in, that actually resides between the Homestead subdivision and the proposed quarry. When they went to the site, they actually then understood locationally how far it is from their home, as well as the fact that the petitioner maintained existing landscape and perimeter vegetation in order to help control the dust and both the noise. It was also demonstrated to them that in the initial stage of the quarrying activity, they tend to basically start cutting downwards for maximum depth of 80 feet, no different than the existing quarry. So over the years, it will move downward, and that action alone will also help ameliorate any noise or dust impact. In addition to their obligation within conditions to constantly use dust control measures, dust management practices basically to control the dust. So I think all of that combined made the homesteaders realize that it was reasonable, and none of them really could demonstrate that there was any direct impact from the existing operation in the way of noise or dust upon their existing homestead. So with that, I think gave them sufficient reassurance that the continued operations into the new project area could likewise properly mitigate any noise or dust impact.
So you can put a buffer zone, some kind of buffer zone, and so I control the dust. You're not going to provide any CUI.
Yeah, so what we're gonna do is we're gonna establish stabilized construction entrances to minimize the dust that's trapped outside of the project area. We're gonna maintain the vegetation buffer, and we also truck in water to spray down the roads to keep the dust down. It's very minimal because most of the rock that's traveled over, it's from the quarrying operation, and there's very minimal dust because no crushing is done in the actual site itself. So it's very minimal. And then the other thing that we also did was we committed to a set of hours to even further avoid any kind of noise disturbance in early morning, late night, weekends.
Thank you.
Good morning. And some questions on some of the recommendations on number 11, mentioned about the vegetation or given how you shall be removed. Assuming that they're looking at needs to be cleared, correct? If all woody vegetation I found, that's right.
A big portion of it has already been disturbed and cleared by the county. They were in there prior to us, so a big portion of it is already, but there is a portion that would need to be cleared.
And I guess that you all are by recommendation for that.
Yeah.
Thank you. And recommendation number 13 talks about the Hawaiian goose in the vicinity during operation. I'm assuming this is when you're in operation and you encounter this. It says that you're gonna stop work and then inform go far. Is that how do you plan to do that with your employees? Is that a policy? Is that something that you're going
Yeah, so we have a quarry supervisor who's assigned to, and he opens and monitors the area on a daily basis first thing in the morning. But also in the 12 years that we've been right adjacent, next door, we've never encountered them. That's not to say we'll never, but it's we've never seen them.
Okay, so the policy is daily morning for
Yeah,
supervisors.
there's a supervisor monitoring throughout the day, first thing in the morning, and he's the last day.
Okay. And then on recommendation 14, talking about the shear rollers and applicant showing some shielded outdoor lights, direct light downwards. How many lights are we talking about?
We're not even going to be working at night.
Are we lights that are going to be installed? Oh,
And even in the current area, there's no link.
okay, thank you, sir. Let me just caution you, because we're doing a Zoom recording, hold your responses to the questions.
Oh, okay, sorry.
You guys.
Oh,
Audio.
sorry.
No, I think we got it.
Okay.
I'm trying to help you. Okay, Commissioners, any additional questions? The chair has just more of a comment than a question. I am particularly gratified by particularly healthy. Also, the arts are reading education, we're very concerned. Education is disturbed the state. Actively leaving Hawai'i. Really encourage you to make something you can have. Really important consideration. We appreciate the primary purpose of your enterprise, not forestation. That's chance for questions, commissioners, for the commissioner. Okay, recognizing it's now 10 o'clock, I'm going to take a 5-minute break and we'll return. We'll be back on the record. 10 o'clock.
Dan Morris,
Yes, sound check, ready to go, although I wasn't getting sound.
Checking to see if you can hear us.
Got it?
Here's now testing 1, 2,
Yes.
3.
Yes, thank you.
On, are we recording? Okay. 10:08, we're back on the record. So we'll turn to the county. County, please make your presentation.
Morning, Deputy President. Good morning, Deputy Corporation Counsel, the Attitude Planning Department, also present with Jeff Darrell and Secretary. As articulated by the petitioner and pursuant to our prior recommendation, and based on your review of the record, we are asking that this land use commission approve the special permit document 22/2012. Planning department staff, Mr. Darrow and Mr. Kay, are available to answer questions if you have concerns.
Thank you. Commissioners, any questions for the county? Their position. Commissioner Higashi.
I'd like to know, after 30 years, the lifetime of this special use permit, what's going to be there? What the planning department required within special use permit?
Excuse me, I think I would suggest I need to ask you to swear you in. You swear that your testimony will be the truth.
Thank you.
Proceed.
Thank you, and thank you for the question, Commissioner Higashi. My name is Christian Kay at County Hawai'i Planning Department. So what's going to be there afterward is largely required as a part of their land license, and will be essentially laid out in the document that the applicant agrees with the state on the closure, as well as in consultation with the KPFA and DHL, as it's laid out in the conditions of approval. So those things are those recommendations that we made and conditions that we recommend to be added are largely controlled by the state, as well as the agreement that's going to come out in closure.
The reason why I asked that is that I have we've been on the commission, I think in a hard position of special use permit for myself. And given the fact that it should be temporary, used because it's unusual and multiple uses. So my question really is, what do you folks have planned for that area? If you're going to keep it in industrial, why not move it all out? Utilize it for industrial purposes and carve out specific controls over it or kiosks and things like that. So that's my question. 30 years from now, what do you
I don't know that I can accurately answer that question. It's state land.
that's the question that I have. What's going to happen? How will it, are we going to bring back to agriculture? Are we going to build up the industrial use? I'm just, because especially use permit is so temporary, future.
Well, you should have always got you got to deal with voice coming.
Thanks, swear you in.
Oh, thank you.
You swear your testimony you're about to give will be true?
Yes.
But please proceed.
This particular area is, as you mentioned, a very industrial type area. We have the airport, we have a number of quarries in the area, and we also have this old airport. So there's different types of uses that we have to be considerate of. We are currently going through our general plan amendment right now, and those are issues being reviewed and are being proposed to be changed, especially with the amount of quarries that are coming in this particular area. Unfortunately, when it comes to quarries, it's not as if you can say, we're going to make this area an industrial area for a quarry. You have to have the material, so the quarries go to where the material is. This area happens to have the material that's utilized for quarries. And fortunately, it's in an area that is industrial in nature with all the different land uses that are occurring in the immediate area. So we are definitely looking at changing this particular area to line up more with the industrial type uses, as well as taking into consideration the preservation of the existing old airport.
Well, I'm going to have my comment to Commissioner Oligacci. One of the concerns that this commission has is that there's agriculture, a lot of agricultural land. And the developer will look to use some of that land for industrialized purposes. And there's a perception that it's easier to get a special use permit than to go through the process of district boundary amendment or urbanizing here. So we're frustrated when we see special use permits come in with 30, 40, 50-year terms, because that's not the intent of a special use permit. Is to use the agricultural land for a limited time and then return it to agriculture. So if it's clear that it's an industrialized area, it probably will be an industrialized area perennially forever. Our sense is that consideration of the district boundary amendment makes a lot more sense, even though perception is it might be a little more difficult. So as you go through your general planning exercise, we would encourage you to take that perspective into account.
We will. Thank you.
Mr. Chang.
Thank you. I have a question. Perhaps we should ask this of the applicant as well. This is, you and I is the landowner, and there's a license that's been issued. And I did notice that the owner signed the SUP application as the landowner. How can we please follow the conditions of the planning commission?
So maybe, a question better answered by the applicant. It is our understanding that the applicant's been in communication with, land division to try and, give that statement. But again, didn't be successful in doing so.
The chair recognizes the petitioner.
Thank you. Commissioner Chan, thank you for the mentioning. I'm sorry, Darren Arai, assisting, the petitioner. We reached out initially back in April of this year, and since April, we have attempted multiple times via email and by phone call to receive some form of confirming statement that the landowner, which is the LNR, will agree to abide by any conditions set forth under the special permit. To this day, we have not received a response. So it's not without the lack of trying. We really tried because we knew what was embodied within the rule.
That could be a little problematic. If DLNR has objection or if any of the conditions and somewhere in the system where they can check. So, we should have sufficient earlier. It doesn't feel a little uncomfortable because we have an encumbrance placed upon the land without the landowner approving this. And I know, and I'm certain we have tried diligently to try to get this approved, but it would appear that this is all subject to DLNR's approval. And DLNR objects to any of the conditions. I think we're in a position to be contrary to the landlord. You see the quantity that I feel like I'm interested in.
I understand the quandary, not only on your part, but also on the part of the petitioner. As landowner, and for the very reason you stated, I am disappointed that a representative of the LNR is not present here as a party. That is a concern. But, if I understand correctly, once the Windows Planning Commission makes a decision for this recommendation, every step along the way, I believe the Department of Land and Natural Resources is copied on this decision as the landowner. So they have more than adequate opportunity to respond. So at the same time, we are concerned that due to the lack of timely response that these proceedings could be in jeopardy, and we would be able to make that happen. Especially when concerted and sincere effort was made on the part of the petitioner.
I concur with your concern. But the former deputy attorney general advised people not. One thing to have them copied and receive notice. It's another thing for them to actually approve this. And in the absence of their approval, this is a very difficult position.
We go back to here on 2 weeks, right? So before then and now, could we get some kind of written letter from them? Maybe? No.
May I offer a suggestion?
Please do.
Given the importance of that communication to these proceedings, is it possible that the Land Use Commission can make a specific direct request of the DLNR to refer rather than the applicant, the petitioner? I mean, we tried and obviously our voice is not resonating at that level.
Before I respond to that question, I'd like to recognize.
I don't know that we will be any more successful, but I'm willing to offer to reach out to DLNR to see if we can get a comment from them prior to the next hearing on this matter.
No, I appreciate that, Mr. Lee. I feel uncomfortable that land use commission, I think it would be more appropriate that your office reached out to them. Because I think it's, we have to confer with our deputy attorney general, but we can take an action in light of this.
Mr. Oliver. With the executive session. Where we are, deputy attorney general issue of consulting.
Mr. Chair, before you go into executive session, may I make a brief comment about the issue and then you can talk with your attorney further about this matter? Thank you very much. I think the issue that you're presented before you regarding DLNR is arguably not necessary for the Land Use Commission. It will be very necessary for the petitioner because the petitioner has a lease with DLNR. If DLNR is not agreeable or somehow it violates the lease, the petitioner will be stuck because it will not be able to comply with the conditions that it's required to comply with. And that's obviously a problem for the petitioner. But when you talk with your attorney, one thing I think for you to consider is whether it affects the Land Use Commission's and the decision and the validity of the special permit that is issued. The reason I say this is because the special permit by its terms is conditioned upon certain matters determined by the county and subsequently by the Land Use Commission. It binds, it is only valid if those conditions are being met. If those conditions are not met, then there is either a violation or the special permit is no longer valid. So the ability to use the land for this use is, it doesn't matter if DLNR doesn't want to be bound by it. If the land is to be used for this purpose, it must comply with those conditions. Now, I will say that if DLNR chooses not to forego, if for example, the petitioner gave up the lease and DLNR becomes the owner is now the holder of the property interest, if DLNR can simply say, I don't want this special permit anymore, I'm not going to use it for a quarry, and then the conditions of the special permit will no longer apply. The conditions are contingent upon the ability to use the land or the desire to use the land for that purpose. But as long as it is used for that purpose, whoever is on that property must comply with the conditions set out in that special permit, regardless of whether DLNR agrees or not. So it certainly affects the petitioner, because there's a separate contract question the petitioner needs to address, but it doesn't address the Land Use Commission's power to impose conditions or the validity of the special permit, regardless of any DLNR approval or non-approval. Thank you.
I have a vote. All in favor, say aye. Let's do session.
So stop recruiting, right?
So let me know for the record. Go into executive session. Back on the record is 11:01. So, this is just completed. Clarifying questions.
Madam Chair. My name is Commissioner Kamakiao. I have a question for clarification for the city and county of Hawaii. In review of the TNJ question, here's my question for clarification for land. The website, the property tax office of County of Hawaii. You guys identify the state of Hawaii Department of the landowner. Can you please verify who the landowner is? Darren Roy on behalf of the petitioner. I'm sorry, my apologies. I wasn't sure who the question was being directed to, but the question was directed to the city council. And, yeah.
Susanna Dupla, Deputy Corporation Counsel for the Sound. Our information, the DLNR, Department of Land and Natural Resources, would be the landowner. Also for the commission's information, we do have Department of Land and Natural Resources, Land Division, District Land Agent, Williams P. Heights, present to address the concerns both about their recommendations and possibly for this department about activation. Would you like to have him sworn?
Forward as a witness.
Yes, based on mission.
I'm sorry, may I ask you to speak up, please?
Commissioner Ohigashi. Anyway, and somebody also following up on last question, I just wanted to know why would it be DOT on the county website?
May I turn the microphone over to
That's
the
one part.
representative from the Department of Land and Natural Resources to address that ownership question?
Yes.
Thank you. I'll yield my seat.
Please be looking to see the market. So please state your name and I'll swear. Good morning, my name is Gordon Knight. I'm the District Land Agent for the Department of Land and Natural Resources Land Division. Answer the question. Good morning, Mr. Height. Good morning. Ask you about your testimony today. You can swear your testimony today will be. Please proceed. The question was, why did the coffee shop under Department of Transportation on the county tax website? And I can answer that question because we don't input the information on the county website. That will be we asked the question to the county and they said the DLNR would answer it for us. I think we're back to the county. Commissioner.
The reason why I asked the question because the adjacent properties are also listed under the Department of Transportation and on the DLNR.
There are several properties that are under the Department of Transportation. Those are ones that are associated to the international airport, but the surrounding properties are actually some of the mixture of Department of Land and Natural Resources land and Department of Land homeland. So it's all state land under various jurisdictions. This particular parcel, to the best of my knowledge, is under the Department of Land and Natural Resources.
So I will now ask Chair of the Corporate Council of the County of Hawaii
what is your interpretation of who owns the land? Because in the filing of the special permit, you need due process needs to be questioned.
Deputy Corporation Counsel Savannah, based on the information before us and based on the information in the record, our submission that is that this would be land owned by the Department of Land and Natural Resources. Oh, we would have to further research that. I wouldn't have to answer that right now. I would be happy to do that. But everything happened for us on the record. We say Department of Land and Natural Resources is one of that. And based on the commissioner's questions regarding the petitions, we do have a representative from the Department of Natural Resources.
I'm sorry to interrupt, but if you could please speak into the microphone, I'm having a very hard time hearing.
Thank you. We did invite a representative from the Department of Land and Natural Resources to answer your questions regarding the petition and whether the landowner is willing to submit to those conditions.
So that will be helpful in a moment. But I'm going to, we're trying to figure out what is the appropriate protocol and requirement for the landowners in current. So I could be through ask the commissioner to change. She wouldn't mind to use up to speed with what we've learned or review relative to administrative rules.
Thank you very much, Mr. Chair. This is Commissioner Chang. I hope Mr. Morris, you can hear me. I would suspect that the petitioners are well aware of the rules as they use the right term, acknowledgement. So I am reading specifically Hawaii Administrative Rules 15-15-95 related to special use permits. Section 8. It specifically reads, and let me get to the relevant part. Any person who desires to use the land within ag or other permissible ag uses may petition the county planning commission with the special use permit is desired, provided that if the person is not the owner or sole owner in sequence of the land, the record shall include evidence that the person requesting the special permit has written authorization of all fee simple owners to file the petition, which authorization shall also include an acknowledgement that the owners and their successors shall be bound by the special permit and its conditions. So I guess the question is one I'm hoping Mr. Haidt you can address from DLNR standpoint, but it's all, but I also have a question in relationship, is the record complete? Did the county send us a complete record in the absence of a written authorization from the owner, which is so I will leave that up to you. That's the rule that I was looking for in the question that I read.
So let me add further the commission's interpretation that there are alternative ways to comply with this. One would be if you have written authorization, generally committed the landowner to abide by whatever conditions like alternative ways might be relative to specific conditions. So those are the way forward that you see relative to we're asking, what's on the record and what goes on.
And I might take us back to the prior question about ownership. Based on our review of documents that are publicly available, the State Department of Transportation is the lessee of the property, but the property is owned by the Department of Land and Natural Resources.
clarify, the Hawaii Department of Transportation would be on the tax map. With respect to your other question.
Wait, let's stop. One at a time. So now we have a situation where the subject land is owned by DLNR, licensed or leased to Department of Transportation, and now it's subleased to Yamada and Son. So here leased to the Department of Transportation.
There is a 2,400 acre parcel of land that was leased to the U.S. Department of Transportation in front of the airport. Let me clarify.
Please clarify.
Again, Christian K, County Hawaii Planning Department. The area that Yamada and Sons are under contract for is a 37.882 acre portion of the larger 2,407 acre parcel upon which the airport is a part of its scene. It's a huge parcel of land. According to the records that we see from real property tax, the United States Department of Transportation is a lessee of a portion of that larger parcel, but I don't believe the area that Yamada is licensed for and the area that the airport is using overlap.
Okay, so let me reiterate what I think you said. 2,407 acre parcel. TMK. Up to 2,407 acres, a portion is leased to DOT, and a portion is directly leased to Yamada.
I don't believe it's a lease, Mr. Chair. I believe it's a license. The area is under license, but
So license, portion is licensed to DOT.
pardon, a portion is leased to DOT. The portion that Yamada is asking for is licensed to Yamada.
Directly.
Correct.
Okay.
So if I may, Mr. Hyde, if you could answer the question about DLNR's and the owner, your knowledge as to the conditions of the proposed special use permit.
Okay, yeah, I'm going over these meetings right now for the first time, so, we're not able to review the conditions are acceptable to the state. Nothing here that really stands out as anything that's not compliable. So I would have to say, initially, that it would be
What's your mind?
So I'm looking at a letter from Mr. Orion to DLNR. Letter is dated April 29th. He requesting a written statement. The state of Hawaii as the owner and licensed area acknowledges that will be bound by the subject special permit and condition of approval should it be approved by the state land use commission for fitting. I guess my question is, was there a response to the request? I guess this question holds that.
Yeah, no, I am on behalf of the petitioner. No, we have not received a written response to the April 29th letter.
Thank you.
DLNR, did you ever see the, do you know when receiving this letter and when you respond?
Okay, that's what I do. Just as you acknowledge receiving this letter. And I do not believe we would be able to respond in a timely manner.
What I understand is you've given an oral. Well, let me ask you this question. Are you authorized by DLNR to the conditions of the special use permit?
Typically, that would be something that I would move up the chain to my superior, have them review. Also have the Attorney General's office review it, just to make sure. I mean, do I have the authority to approve it? Yes, I do. But it would be something I would want to vet before I do.
I'm a little confused by that seems to be a little so one, are you authorized? And if you are authorized, are you authorized to be bound by these conditions? That's the yes or no.
Yes.
So I appreciate it. So is it fair that your statement today on the record is DNR's authorization to be bound by the conditions?
Yes.
Very good.
Mr. Oligashi. My only comment, I have a comment. You're not taking evidence. And the statements that you have made, not part of the record that you can consider. That is my problem. Unless our Attorney General, something that we can set. Then statements that we make should not be part of the issue. And that's my comment. I think another way of saying the same thing is the planning commission. You can check that box before it is. So it has to count, just for clarity purposes. Did the county determine if it's reasonable one more time? If there is written authorization of the simple owners, which in this case would be the LNR, in filing this petition, which authorization includes an acknowledgement that the owner and their successors shall be bound with a specific by the special permit and its conditions.
Deputy Corporation Counsel Susanna, we have not. Our securing the LNR agent today was to answer your questions, but we absolutely understand that that's not part of that.
Chair. Commissioner O'Donnell, I just have one. I think that the record on file has a deficit in it, expressing where exactly it is. But if it's requested for where applies, whether or not overlap statement that planning department seems to have made think would like I think that the record it never comes back again. Part of that. It's required to do that. Should include something specific to clear up that type of that your own maps. I'm just saying.
If I may respond, sorry, Kristen Page, County Employee Planning Department. While I don't have the exact meets and bounds of the lease area for the airport relative to the forest area, my language that I sent, I can change to I am certain to be
It's not part of the record.
That is not part of the record. The question relative to DOT lease was property.
Commissioners, anything further filling out? Commissioner,
Perhaps maybe we're gonna answer the question. But based upon the Corporation Council's statement that, that is not part of the record. Are you of the position that the matter that the county submitted is incomplete? Submission before county?
Suzanne, people at the Corporation Council. Our submission was that we had not provided written authorization from the Department of Land and Natural Resources. When they signed the application, we assume that they're agreeing to the application. The permit, even if it is granted by the commission, cannot be effectuated without those conditions being followed. So if for any reason the landowner, Department of Land and Natural Resources, had not agreed to provide, the permit would not be valid. It would not be.
that was part of this. Anything further from the council?
Nothing further.
I'll turn to the OPSD.
Thank you. Good morning. Deputy Attorney General Brian Yee on behalf of the Office of Planning. I'm going to address some issues I did not originally plan to address, so I may be a little disjointed, but let me just start with some of the bigger issues that sort of have arisen at this hearing. Okay, sorry. Let's start with the issue of the written acknowledgements by DLNR to be bound. What has come out of this hearing is that a written acknowledgement does not exist in the record. What you had before you was an individual who, from DLNR, said, yes, we would be bound, but that is not, you could certainly consider public testimony from DLNR saying we support the permit, we hope you grant it, you can accept that kind of testimony of DLNR's intent. The harder part, though, is can you accept evidence? And the evidence has to be set by the record below. And you can't submit more, you can't accept more evidence. So you can accept oral testimony about support as you could from any other public member, so you could accept that from DLNR. But the question is whether that's sufficient. Let me note for you that what you're talking about is really more of a rule requirement than a legal requirement. And I'm going to get back to this because it's relevant because LUC rules 15-15-34B allows the commission to waive any rule where doing so in order to avoid manifest injustice where the party has attempted in good faith to comply. So in this particular case, you don't have the written acknowledgement. You have an oral statement, you don't have a written acknowledgement. And as I said, it doesn't matter if you have a written acknowledgement, DLNR is going to be bound regardless. whether they acknowledge it or not. They're going to be, they have to, if they want a quarry, if they want to operate a quarry on this site, they have to comply with the conditions, whether they acknowledge that or not. So I just submit to you, you have an option before you to say, yes, that's the rule says we're supposed to get a written acknowledgement. We don't have one. We could approve this anyway, pursuant to 1515-34B, and waive that requirement because we are satisfied that substantively DNR will be bound to the conditions, and we don't anticipate a problem, quite frankly, in DNR's disagreement. So let me just sort of give that to you as a separate item. In addition, there was the issue of the owner of the property and whether the record below was complete. With absolute respect, let me just note, this issue only came about because the Land Use Commission is proposing to offer evidence that's not in the record below. So there's nothing in the record below that says that DOT is the owner of the property. What you have in the record below is the license between DNR and Yamada and Sons, which lists this parcel. Although I will admit, reading a license and the description of the property is difficult. But my understanding from the representations that were made down below is that this is a license for the parcel in question from DNR to Yamada and Sons. And therefore, you do have evidence in the record that the owner of the property was DNR, not DOT. Let me also address the question of the more general question that has come up from Chair Giovanni and Commissioner Ohigashi, sort of more generally about special permits. And how do special permits work when, why should you have a special permit rather than a district boundary amendment? At least as it applies to this case. So let's first acknowledge this property has terrible soil. It's just not good for agriculture. If we did not have a special permit, I would not expect a diversified farm to go up on this piece of rock. You've heard how they had to truck water in. You don't have infrastructure for water, don't expect commercial agriculture to move forward on this kind of soil. Second, so in other words, taking property out of the agricultural district for a use other than what's set out in statute makes perfect sense. It's completely reasonable. But you have asked the more interesting question of, well, then why not urbanize it? Why not go through a district boundary amendment and urbanize this piece of property? And the reason is we are not prepared to urbanize the property now. We don't want the property to be urbanized now. So if you look at the maps that are contained in the record, what you'll see is residential and commercial, and then some agricultural lots, the Pana Eva agricultural lots from DHHL, a small belt of greenery, and then this area, as well as additional forested area. There's also military reserve to the north, and then Hilo Airport further beyond that, and then additional agricultural lots, I think, further east. And the point being made is we don't put land, or we do not put land in the agricultural district because they're wonderful agricultural lands necessarily. There's a lot of land in the agricultural district which simply holds the land. And we use that as a method to manage growth, to be able to manage the urbanization across the state. So we don't put every single parcel of, or even the majority of property into the urban district, because at some point in the future, we don't know when it would be appropriate for urbanization, because then urbanization grows without any management, without any control. And how are you going to impose conditions if you don't know what you're going to do with it afterwards? So this is not going to be used for quarrying forever. It will be used, it is a particular geological resource that we do want to allow for economic development purposes to continue and to occur. But after they're done, we don't necessarily want to urbanize this property that's among either forested area or agricultural lots, at least not today. Because when you mix those uses, when you have urban right next to agricultural, you often have conflicts, right? You have issues of loud machinery, and you have issues of smells and noise and pesticide use and all sorts of things that are completely normal and appropriate for farming or agricultural property, but which just annoys the heck out of any living resident next door. And so you try to keep them relatively separate and keep them in particular spots. So you don't want to necessarily urbanize this area for either commercial or residential or other urban uses at this time. So what do we do in 20 or 30 years? We don't know. That's the point. It is licensed to Yamada and Sons for 20 years, and after that, it reverts back to DLNR. DLNR has not expressed any particular use for this property in 20 years. And so if we don't know, it goes back into the agricultural district, and DLNR will have to then go through a district boundary amendment if they then decide at that point whether it should be used for any other purpose. But till then, it will then be held in the agricultural district, as so many other acres of property are being held in the agricultural district, simply as a means of managing growth and managing development in the appropriate places at the appropriate time. So this is not ready to go into urban today, but it's completely appropriate to use this particular geological resource today for quarrying, given the conditions that we have today, the circumstances we have today, and the conditions that were imposed by the special permit. In addition to the issue of urbanization, there's also the issue of whether there are adequate conditions that were imposed. I think there have been a few questions. I think most of those questions have been adequately resolved. The Office of Planning and Sustainable Development is satisfied that if the special permit is granted, the conditions do mitigate, the impacts have been identified, the conditions adequately mitigate those, except for one condition, which OPSD admittedly late is proposing and recommending to you based upon a Department of Transportation concern that nearby properties should make sure they do not have, they do not create wildlife attractants in violation of federal requirements. This is reflected in document 16, which is in the record before you. It is agreed to by the petitioner. My understanding is Corporation Council and the county have no objections. We have the particular language that's been agreed to, so hopefully you will also see fit to impose that condition if you grant this permit. I will not take more of your time, but I would be happy to answer any questions.
Thank you, Mr. Yee. Commissioner, questions for OPSD? Once. Yamada.
Thank you, Mr. Lee. So it's a very good explanation. So, in your opinion, would you say the question in front of the land use commission is, the first one anyway, is whether we, based on the HRA that allows us to accept any of the other rules, that would be our first, I guess, question to answer, whether this commission would want to waive or accept that particular HRA. Is that correct?
I think that's fair, yes.
Thank you, Mr. Lee, on the question.
Yeah, that was my interpretation as well. That a motion to waive that rule consideration that was taken up.
I appreciate giving us ways to define the but I'm kind of sure that the commissioner has exercised due diligence and really tried their best to obtain the required authorization We have Mr. Height here today, who is orally represented, that he found we have a license that's been approved by the board. So it does appear that, you know, all of the necessary substantive safeguards are in place. And it's a matter more of a process, but I appreciate Mr. providing us with 35.
Let me just double check. I thought it was 34, but let me just. (15) Unless contrary to statute, the commission may waive or suspend any rule when the commission determines that a good cause exists is also an obligation.
Further comments on position. Took your comments to be specific. Our comments were more generic. It's uncommon for us to see, as we have this, that there's agricultural land, there's protection of special needs, all of which is present industrialized area. It's logical that it needs consideration here. That's why I had asked the county that they reflected upon exercise general planning. Take that into consideration. This is specific. These are my own.
Say that you're not sure of what you want to use it for 30 years from now. Begs the question, how you plan. I think finding the county does the planning process rather than DLNR to engage in what they want. That's why I asked the question. DLNR at this point in time seems to be just allowing this spot. That's the only thing about it. So what do you guys want? And I want to rather than applications, people want, especially this permit, to fill out the mosaic of properties. And I think that doesn't work out. My question.
Just
Thank you, Commissioner Agashi. Commissioner
I think it's a great question, and I absolutely think it's a question that should be asked. And I think the county does ask itself these questions constantly. I do want to note that the county plans typically, I don't want to speak for the county of Hawaii in particular, but the county plans typically are reviewed every 10 years. And they're intended to be living documents. So they're intended to look forward a certain number of years, but not too far. If you go too far, the plans just aren't useful. It's just difficult to plan that far ahead. So it's always good to ask the question, what am I going to do in 30 years? But not necessarily to put it into the plan. Because you don't want to approve developments that are going to be needed 30 years from now. You're looking to approve developments that you need like the next 10. So that's it. Thank you.
Other questions for OPSD? We'll now revisit public testimony for a second. Once again, are there any members of the public who wish to testify on SB 22/4 Yamada?
No, Mr. Chair.
I think you do have something on there.
Commissioner Chair, if I may add one, offer one of the concerns Commissioner Hill. On page 746 of the record, there is a memo dated April 21, 2022 from Department of Land and Natural Resources to the Planning Department, acknowledging receipt of their request, which they would only do if they as a land. Just to address any remaining problems. Thank you very much.
That had to do with the question of DOT versus DLNR, not the response to the letter.
Just the concern of actual ownership. 746 of the record.
Okay, commissioners, looking at the hour and I see the lunch is here, is that correct? So, we're about to go into deliberations. I'm going to suggest, commissioners, of course, advise otherwise, within 30 minutes. Come back into the Tuesday. Is 30 minutes adequate for you folks, or do you need an additional 15 minutes for one? That's to the party. Okay.
On behalf,
30 minutes is sufficient.
Okay. Petitioner.
on behalf of the petitioner, W.
Oh, no, yes. You get to stay. I can read.
Okay, 22, back on the record. So the commission will entertain deliberation at this time. Commissioners, chair will continue the motion regarding how we should proceed this. Commissioner Chang.
Well, thank you, Mr. Chair. I'd like to make the following motion. One, the commission acknowledged that Hawaii Administrative Rule 15-1595A requires written authorization from the landowner, the owner, from special use permit and the conditions. The record provided by the county do not include the written authorization. However, the owner representative, Mr. Hawai'i, the land agent, orally approved the conditions. The petitioner demonstrated good faith to obtain the owner's approval as included in as noted in the records, and three, that the owner approves the license. Second, pursuant to ECR 15-15-34B, the commission may waive any rule, one, for good cause, and in this case, the 45-day requirement for LUC to take action is quickly approaching, and two, strict enforcement would result in massive injustice on the petitioner who was demonstrated to have diligently sought DLNR's authorization. Accordingly, I move that the commission waive the requirement of 15-1595A requirement. And three, the commission approves the special use permit as distributed to LUC by the county with the addition of the condition provided by OPSD. Thank you.
Before I take I want to summarize what I think I'd like to take parts rather than and we and your personal part of your
So the first part of the motion is one that Land Use Commission acknowledges that the requirement of 15-15-95A requires the authorization of the landowner to the special use permit and the conditions, and that the record provided by the county does not include the written authorization. To waive that requirement, because one, there's been good cause, the 45-day requirement quickly approaching, and two, strict enforcement would result in manifest injustice on the petition. These are actually, okay, these are languages, words specifically in the rule.
Okay, so do I have a second motion to waive 1595?
I'll like to second the motion, but I just would like to offer comments to the petitioner and the county planning department. Clearly, someone knew that this was a requirement, especially in the letter from Mr. Ryan, stating that the applicants receipt of this written acknowledgement from the state of Hawaii is essential to the proper proceeding, and as he interprets the rule, there is no exception to this requirement. Clearly, someone knew about this requirement. And it put us in a position to do a waiver, which I don't think we would want as the land use commission to get into the habit of. But just to offer that comment, but I'd like to second that motion. Thank you, Mr. Chairman.
Mr. Chang, you want to speak to your motion? You already did.
Mr. Chairman, it's almost done.
Commissioners, any other further comments? Mr. Higashi.
I'm reluctant. But reason why notwithstanding the fact that petitioner seriously cavalier attitude county's position in the proceedings below and in this hearing regarding this particular matter has resulted us to push this acceptance through. And I would only vote for it because the petitioner has said done all the work in trying to get the LNR. And I called the county because lo and behold, despite the warnings of Mr. Ryan that letter, lo and behold, at this hearing, we're able to produce the DLNR representative. County went out and got it. So I think if more attention was placed in the proceedings below, even after the proceedings below to that, or to have the county get that as part of the record, rather than bootstrapping it today, would have resulted in a quicker hearing, much more medical point of view. I would never vote for this again. Because frankly speaking, I think everybody's on notice. But that's the procedure. Thank you, Mr. Chair.
Thank you, Commissioner. So the chair will also be supporting this motion. I feel it's unfortunate that we've got to take this step. I agree with Commissioner Lonnie that this will not be a habit. This commission routinely take this step. If we recognize Commissioner Higashi has pointed out that the efforts of the petitioner see if they tried to get what was missing. Despite the turns out we have what I would call a convenient house. Going for. I can assure you of that. So I also wanted to say that in these types of special use permit, always owner present. Not gonna have to resurrect them. Same. Have them here, on record. Next we will.
Thank you, Mr. Chair. The motion is to waive our rules under section, as authorized in section B, with regard to the acknowledgement of the landowner as required in section 95A. Commissioner Chan. Aye. Commissioner Lemon.
Aye.
Commissioner Osborne. Commissioner Cahill.
I oppose.
Commissioner Oviedo.
Aye.
Commissioner Kamakaya.
Aye.
Commissioner Kura and Gabriel. Commissioner Chair Giovanni.
Aye.
Thank you, Mr. Chair. The motion passes. Six affirmative votes and one.
Thank you, Mr. President. The commissioners now we may proceed to deliberation. This way, in recognition of the fact that the record below does not include an explicit acknowledgement by the landowner or in position to consider the request before.
Thank you, Mr. Chair. Thank you. I move that the commission approve the special use permit as transmitted to us by the county with the addition of the condition proposed by Office of Planning.
Second to that.
Mr. Chair. Second.
Seconded by Commissioner. So Commissioner Chang, you want to speak?
Thank you, Mr. Chair. Notwithstanding the procedural defects in this matter, I think both the county, quite frankly, I think county and OPSB notice that as Commissioner Bohibachi and our chair, we have had unfortunately occasions where the landowner is not present, and we are binding them to either the application or to conditions. So please, you are on notice that we are expecting when matters come before us, that that should be raised at the lower level. If it comes up as a SUP or boundary amendments or other deck actions that may involve a landowner who's not present, if that's a critical component of LUC. Notwithstanding that, I believe that the petitioners have adequately addressed the concerns that have been raised both by the government agencies as well as the community, and my own concerns about the ophea tree, maintaining that the forest, because the ophea tree is an extremely significant cultural resource. I think this petitioner has demonstrated in its past the adjournment that they are a good, that they are good steward of the land. And I believe, based upon the petitioner's personal representations today, that they will continue to be good stewards of this adjoining land. And so with that, and that's the reason I made the motion to support what's being proposed. Thank you.
Thank you, Commissioner Chang. Come on, you want to speak to your second?
Thank you, Mr. Chair. I support this petition based on the recommendation that the petitioner will be following
based by the planning commission, and they have adequately answered my question regarding some of the conditions. Thank you, Mr. Chair.
Support this petition. One of the reasons why is the questions that I asked have to do with whether or not an increase in the amount of activity. And it appears that we're maintaining the same amount of activity that they had. In addition to that, what really told me was the fact that actual crushing of rocks takes place on-site and on your own personal crushing site. That makes it less of an industrial company and more something that is less intrusive in the area. Yes, it evident in this hearing, past comments in other hearings. I'm not a fan of this, but in this case, I can see the necessity of it. I see the minimal impacts you're providing. I want to thank you. You guys did a good job.
So the chair will support this motion as well. I concur with the comments of my fellow commissioners. Support the motion. I also want to commend Yamada's and their families. I think you, stewards, I have played an important role in the community here, service you provide as part of your business. I appreciate you taking this matter very serious, appropriate, well represented.
Thank you, Mr. Chair. Welcome to approve this the special permit with the addition of the condition proposed by Office of Planning and Sustainable Development. Commissioner Chen.
Aye.
Commissioner Yamada.
Aye.
Commissioner Higurashi.
Aye.
Commissioner Kamake.
Aye.
Commissioner Kayali. Commissioner Hopper.
Aye.
Commissioners Okuda and Cabral are absent. Commissioner Chair Giovanni.
Aye.
Thank you, Mr. Chair, for the motion.
Thank you very much. Thank you for all your time.
Thank you very much.